Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and we are going to be continuing our series of going through the rules of evidence. Now, I happen to use the Alabama rules of evidence, but they're very similar. And this will be Rule 801, Definitions of Hearsay. And we'll do this particularly at the end of this video in the context of a debt collection lawsuit. So let's see what we get with Rule 801. It has four parts to it. It first defines what a statement is, and then what who the declarant is, and then what exactly is hearsay. And then the final section is statements that are not hearsay. Now let me say this. There are a number of rules after Rule 801. We'll also look at Rule 802 because it's very short. But there are a number of rules and exceptions, but we have to get this first part. And I remember in law school going through evidence, when people did not understand Rule 801, they never understood the rest of hearsay. And I see this in 25 years of trying cases, that lawyers that don't understand the definitions do not understand how to properly use the rules of hearsay. And so they'll get lost in the weeds with all these exceptions and exceptions to exceptions, and we just go back to the very basics. So we have to get this foundation, or nothing else will really work in understanding hearsay. So we'll be looking at a number of other sections, but we'll focus in on Rule 801 and a little bit on 802. So let's jump in. So Rule 801A is statement. So what's a statement? Pretty simple. It's an oral or written assertion or nonverbal conduct if it's intended by the person as an assertion. So if I say something, that's a statement. If I write something, that's a statement. Well, what would nonverbal conduct be? Well, if you say, hey, which house does Bob live in? And I point to the house on the left, well, that's nonverbal. Did I intend that to be an assertion? Yeah, because I'm saying, yeah, it's that one over there. I'm pointing to the one on the left. Okay. Well, let's look at Section B. What or who is a declarant? And this could be a company. It could be a person. A declarant is a person who makes a statement. Okay. So remember, we have statement, oral or written assertion, or nonverbal conduct if intended as an assertion. The declarant is just the person that makes that statement. Well, let's look at 801C. And before we do that, let's actually jump to the next rule, because here's why it's so important to understand hearsay. Rule 802 says hearsay is not admissible except as provided in these rules. Okay? So 801C tells us here is the literal definition of hearsay. And if you get nothing else out of this video, please understand what hearsay is. Hearsay is a statement. So remember, that's oral or written assertion or nonverbal conduct. It's a statement other than one made by the declarant. Remember, the declarant is the person that makes the statement. So other than one made by the declarant while testifying at the trial or hearing, that's offered in evidence to prove the truth of the matter asserted. So let's look at this. So hearsay is a statement. We got that. Other than one made by the declarant while testifying. So in other words, everything that is said by the declarant while testifying, that's not hearsay. In other words, if you say to the declarant, Bob is on the witness stand, and say, Bob, what day is it? And he says, well, today is Sunday. I'm recording this on Sunday. Well, we can't object. That's hearsay. No, because he's making that while testifying at the trial or hearing. And it's offered in evidence to prove the truth of the matter asserted. So it's being said to show you that this really is the truth. Now, let's use another example, because here's where a lot of people get confused. So Bob is there on the witness stand, and he's asked a question. He says, well, let me tell you what Susie told me. See, a lot of people, even lawyers, think, well, that's not hearsay because he's there on the stand. No, it's the question is the statement hearsay? Well, what's the statement? Well, he's saying, well, let me tell you what Susie told me. Well, that was a statement that was made outside of court, And if he's offering that to prove that that's true, in other words, well, Susie told me that, Jack is the one that crashed his car into your house. Okay, well, offering that to prove the truth of the matter asserted. So we just have to understand what hearsay is. It's not when the person's testifying live in court and you're asking them questions. I mean, obviously, that's not hearsay. But if they start referencing statements that were made outside of court, and if those are offered to prove the truth of the matter asserted, then that is a hearsay statement. So I'll give you an example. We'll wait till the end because I want you to see this in the context of a couple of sort of typical things that come up in a debt collection trial. So just remember, right now, a statement, oral or written assertion, or nonverbal conduct intended as an assertion. The declarant is the person that makes the statement. Okay, so if I'm in court testifying about what you said, then you would be the declarant, right? Because you're the one making the statement. I'm just sort of relaying that, and that is sort of classic hearsay if it's offered to prove the truth of the matter asserted. All right, now let's look at some exceptions. The next couple of slides will be, these are statements that are made outside of court that are intended to prove the truth of the matter asserted, but we classify these as not being hearsay. Now, when I took the rules of evidence, a lot of this was considered hearsay, but an exception to hearsay. The more modern way is just to view it as, we're just not calling it hearsay at all. Okay. So here's the first one, a prior statement by a witness, not a party. So a party is the plaintiff suing you, defendant being sued. This is just a witness. So let's look at this. The declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement, so remember, statement is oral or written. And it's, number one, inconsistent with the declarant's testimony, okay, and was given under oath. So we bring in a witness to a car wreck. Okay, so Jack is the witness to the car wreck. And he testifies at trial, the light was green. I say, wait a minute. I took his deposition. He gave testimony under oath where he said the light was red. So I can bring that up. That's a prior statement that was offered to prove the truth of the matter asserted. He said the light was red. And now he's being inconsistent. So I can bring that up. Well, how about a statement that would show consistency? That seems kind of odd, right? So again, we'll just use a car wreck for this example. So Jack says, the light was green. And the other side says, you just made that up. You just recently lied about that. Or you were just recently improperly influenced, or you just came up with this motive to lie. Well, then if Jack is sort of my witness, I can say, well, here's his deposition testimony that was offered under oath, and it's entirely consistent with what he just said. He said the light was green 2 years ago in his deposition. Now he says the light's green. It's consistent. Now, the section C is more in the criminal context. Okay, so we're not going to really focus on that. Just identification. All right, well, let's look at the other example of when a statement, which meets the definition of hearsay, but we just say it's not hearsay, if it's an admission by a party opponent. So not a witness, but an actual party. So the plaintiff, the one suing you, or the defendant, the one sued. So it's a statement offered against a party. And there are 5 examples here. A party's own statement. So again, think about a car wreck where the plaintiff says, oh, I had the green light. And somebody says, well, right after the wreck, you said that you had the red light and you ran it. Well, that's a statement against the party, right? That would hurt the party. And so that's sort of the classic example. Well, what about this B is a statement of which a party has manifested an adoption or belief in its truth. Okay? So The first example was the plaintiff said after the wreck, the light was red and I ran it. Okay, that's obvious. Well, what if somebody says, hey, that light was red and you ran it, and the plaintiff nods his head, says, yep, you're right. Well, see, that's the same thing because you've adopted that statement. Now, how about Section C, a statement by a person authorized by the party to make a statement? This is more typically going to be a company. Okay, so we sue a trucking company, and the trucking company puts out a statement that says, yeah, our truck driver was drunk and, ran the stop sign on the country road and crashed into the people. Well, it's not the truck driver making that statement, but it's the trucking company making that statement on their own behalf. Okay, and D would be a statement by the party's agent or servant concerning a matter within the scope of agency or employment. So again, kind of the same thing here. And then E is more of dealing with criminal action, so co-conspirators. So let's look at a debt collection trial. So let's say it's Midland Funding, it's LVNV, it's Portfolio Recovery, Midland Credit Management, Calvary, one of these debt buyers, Jefferson Capital. They say, Your Honor, we want to introduce monthly statements sent by Chase or Capital One or Synchrony Bank. Well, for us to know whether we can object to those, we have to say, is it a statement? Okay. Well, that's pretty easy, right? Statement's just a written assertion. Okay. So, yes, it's a statement. Who is the declarant? Well, that would be the credit card company. Okay. Is it being offered to prove the truth of the matter asserted? Yeah, they're offering those credit card statements to say, hey, John, you really do owe $5,000. Here's the statement that proves it. Well, that would be number 3 then, offered to prove the truth of the matter asserted. Is it related to a witness? Okay, remember, this is a prior statement by a witness. Well, no, unless the credit card company happens to be a witness at the trial, which is very unusual. Well, is it against a party? Well, let's say I'm being sued by this debt buyer. Are these statements that would hurt me? Yeah. Are they statements I made? No, I didn't make the statement. I didn't write the credit card. See, and that's why we have to understand who the declarant is. Okay, so we'll come back here. Declarant is a person who makes a statement. Well, if we're talking about, the January 2018 Synchrony Bank credit card statement, I didn't make that statement. That's Synchrony Bank, so that wouldn't apply. So this would be hearsay. Now, there are exceptions for how these could come into evidence, but we just start off, first of all, is this hearsay? Absolutely, it's hearsay. Well, how about a bill of sale from Synchrony Bank to Midland or Portfolio or Calvary or LVNV or whoever it might be? So they bring this up in trial and they say, Judge, this proves that we bought the debt. We bought the debt from Synchrony Bank. Here's the bill of sale. Well, is it a statement? Yeah, it's a written document, right? So it's a statement. Well, who's the declarant? Well, we might say it's Synchrony Bank, or we might say it's the debt buyer. It's one of them, right? Could be both of them. All right. Is it offered to prove the truth of the matter asserted? Well, what are they trying to assert here? That they really bought the debt. Yeah, then it's offered to prove the truth of the matter asserted. Is it related to a witness in the sense that it's some prior statement by a witness? It's either inconsistent or consistent? No. Okay, not at all. Well, is it against a party? So is it an admission by me? So they're suing me, okay? They say, well, here, this is an admission by John Watts. No, I didn't write that thing. It's not an admission by me. It's not my own statement. I haven't manifested an adoption. It's not somebody authorized to speak on my behalf, not somebody that works for me. It's not a co-conspirator. So, see, those exceptions don't work, right? 801D1, a statement is not hearsay if it's a prior statement by a witness that meets these requirements. 801D2, it's not hearsay if it's an admission by a party. It's not an admission by me. So a bill of sale would be a proper objection for hearsay. We would just say, Your Honor, we object. This is hearsay. Monthly statements over here, sent by a credit card. They try to get those into evidence. We go, may it please the court, we object. These are hearsay statements. Now, then it will be on the other side, the collection attorney, to try to argue away, okay, yeah, it is hearsay, but here's an exception to hearsay that will let it into evidence. So I know going through definitions is not the most exciting thing in the world when we're looking at the law. But I'll tell you this, if we don't understand these definitions, we will not understand how to use these tools. It's sort of like saying, I want you to build this house, and you've never built a house, never used any tools. Let me show you what a hammer is. Let me show you what a saw is. And somebody goes, no, I don't have time for that. I want to start building the house. Well, you can't if you don't understand how to use the tools. So Rule 801 gives us the definitions, gives us the tools here. And then as we move into the other parts of the rules of evidence that deal with hearsay, we'll be able to better understand. So we'll understand, well, what is hearsay within hearsay? What are exceptions to hearsay? So I hope that you found this helpful. And remember, if you're not in Alabama, definitely check out your own rules of evidence to see exactly what your particular state and court uses as far as the rules of evidence. But Alabama rules are very, very similar to federal rules. There are some differences, but pretty similar. And most states are going to be roughly the same. Okay, now you do have to get into the weeds and the details if you're outside of Alabama, but hopefully this gives you a good framework to kind of then go look at your own rules and be able to better understand them. Okay, guys, thanks for watching this, and I will catch you in the next video. Bye-bye.